In today's case, the state sought to introduce Facebook messages into evidence that indicated the defendant knew the sexual encounter wasn't consensual. Now, before we go any further, let's kind of take a step back and talk about Facebook's policy regarding retrieval of private messages and account information. For law enforcement, it's actually pretty easy. They email a subpoena and they get pretty much anything. And as you read today's case, the reason they issued the subpoena was because they no longer had possession of the defendant's phone. Now, it isn't stated in the opinion that the messages had been deleted, but it may not be an unreasonable inference, which raises more interesting questions, I suppose. But I digress. For civil process, you'll note Facebook's official policy and that of other social media companies is to argue that they are exempt from complying under the Stored Communications Act. The SCA is a federal statute that says, hey, people have an expectation of privacy, and no one is allowed to peek at that except Uncle Sam. And Facebook fights like heck over this. Just recently they took this issue to the California Supreme Court, where the justice sort of sidestepped the issue, at least for right now. So technically, you can't subpoena Facebook for a civil proceeding. You're supposed to ask the party to just turn it over to you, and that works about as well as putting a grease fire out with water. But, and in law, there's always a but, there's an exception that you won't find mentioned on Facebook's website. If the message or item you wish to retrieve is indispensable to the lawsuit and the person you're seeking information from consents, then the SCA can't be used as a shield. Returning to this case, as a reminder, the prosecutor, they were exempt from the SCA, so the defendant was convicted at trial, and on appeal, he argues that the court erred in admitting the Facebook messages, but the appellate court disagrees. And that's because the subpoenaed information sought for admission came with a certification. It was self-authenticating under Evidence Rule 902, subparagraph 11. And to be clear, the admission of the Facebook records based on that certification, well, they were limited to the information regarding the defendant's name, address, telephone number, and email, as indicated on his account, i.e. records kept in the normal course of business. Now, the prosecutor is doing this because, unlike civil cases, they have a much harder job. They have to show the defendant is guilty beyond a reasonable doubt. For civil matters, we just have to show it's more likely than not that something happened. And as practitioners, if we have copies of screenshots provided by the client, that may be sufficient for reasons I'm about to discuss. Because the content of the messages does not fall under 902 subparagraph 11, but the admissibility of the content from the social media, email, or text messages, well, that can be accomplished through testimony and circumstantial evidence. Now, circumstantial evidence is a term that's thrown around a lot. It just means outside facts that common sense would suggest leads to a conclusion. Such as, waking up to find your furniture scratched up, and although you didn't witness your cat do it, he's the only other occupant in the house, so circumstantial. In this case, the tone, use of language, timing, and unique knowledge contained in the emails, although circumstantial, was enough to lead a jury to reasonably believe the defendant wrote those emails. So although you can claim someone might have hacked your account, how and when those emails were written will allow a judge or jury to possibly conclude otherwise. Anyways, that's all I have. Thanks for watching.